Hello, good afternoon. Welcome to this Brexit webinar. My name is Tony Summers and I'm a partner at MHA Carpenter Box and I'll be your host today. Now, I'm going to start with a Brexit joke. Now, I'll warn you it's terrible, but I'm pretty sure many of you will use it over the coming days, maybe even over Christmas dinner. Brexit walks into a bar with a horse. Now, obviously, this is next month rather than this month. Brexit walks into a bar with a horse and the barman says, "Why the long farce?" I did say it was terrible. But I'm sure you can see the relevance of that particular joke. We're only 5 weeks away from the 1st of January, and we still don't know what rules are going to apply to us doing international business. It's just crazy. This has got to be the longest drawn-out trade negotiation since those affecting Naboo in Star Wars 1, The Phantom Menace. Now, I don't know if you saw what the Governor of the Bank of England said earlier this week. He said rather chillingly that a no-deal Brexit would cause more economic harm to the UK than the effects of COVID-19. Just think about that for a moment. A no-deal Brexit doing more harm to the economic state of this country than the incredibly damaging COVID-19 virus. Like we need that right now. So as we stand, we have a no-deal Brexit, and there are plenty of rumours going around that a deal might be close, but of course we don't know what that deal will entail, and we also don't know whether the various parliaments, including our own of course, will ratify that particular deal. So this webinar is going to focus on a no-deal Brexit. What are the issues you need to be aware of, and what should you be thinking about? And with that in mind, I have two experts. Dan Hobbs is a fellow partner of mine at Carpenter Box, and he specialises in VAT and has been leading the firm's response to Brexit planning. And we also have John Yates, a partner at DMH Stallard, specialising in commercial law. Before we started, we flipped a coin, and Dan is going to be first to kick off with a presentation. But before I invite him to start, I thought I'd point out that there are literally several hundred of you on this particular webinar, so you're all on mute. The Q&A facility has been activated for you to ask any questions. And at the end of the presentations, I'll try and ask those questions that are coming up repeatedly. But obviously, with so many of you on the call, I won't get to ask them all, especially if your question is quite niche. And we may look to do some sort of follow-up on the frequently asked questions that we don't get to cover, be that in an email, a video, or a further QA-based webinar. So Dan, I'm going to turn to you first. And Philip wrote, when he registered for the webinar, "Can I please bury my head in the sand?" Is that a good idea?
I think we all wish we could do that, but it's, I think in some way you mentioned the long drawn out farce earlier, and I think that's really given everyone the opportunity to stick their head in the sand up until now, because frankly, we've not known what the state of play is going to be on 1st of January. So where we are today, we've really run out of time, and it's a shame we've got to where we are, but businesses do need to be taking action now so they can continue their trading relationship with Europe 1 January, regardless of whether or not we have a deal. And I think just before I kind of go into the detail, I think something that's really important for everyone here to know is that assuming we do come to some kind of arrangement with the EU by the 1st of January, what you're going to hear today is not really going to change greatly. Frankly, the main implications of a deal between us and Europe is going to be, as far as what we're covering today, the kind of the tax side of things, is really going to be about rates of duty and maybe some of the administration and simplification procedures. Fundamentally, what we're going to cover here today about VAT and customs procedures are unlikely to change. So this is all still going to be relevant. So don't hold your hopes out that there's going to be some kind of miracle deal come 1st of January and you're going to be able to continue trading as if you are today. There will be changes regardless. So with all that being said, just a quick overview of what we're going to be covering today. So the main kind of changes that I want to talk about are to do with indirect taxation. There's lots of other considerations to do with employment taxes, direct taxes. I'm not going to talk about those today, but we do need to know about import procedures, VAT, movement of goods. Those are the kind of things which are going to really impact the day-to-day practicalities of trade, and indeed your kind of financial processes and ultimately your bottom line. So where I just want to start is just go for an overview of some of the main things which are going to affect customs and import charges. So if we can go on to the next slide. The next one after that, there we go. So there are five main pointers that I wanted to briefly touch upon here. Now, as a starting point, it's important we know about the new UK global tariff that's going to be coming in. Now, many of you may already be aware that we currently are part of a common external tariff with the whole of the EU. And the reason that exists is for competition. What the EU does not want is for it to be better to import goods into one country over another. So the whole of the EU has a common external tariff which applies to goods coming from outside the Union. And that applies to customs duties when the goods hit the border. Now, one of the main benefits to us of Brexit is that we can now impose our own tariffs and agree trade arrangements with the rest of the world. So we're going to be putting in place our own new tariff system. Now, unlike the EU system, we're going to try and keep it simple, but anyone that's ever dealt with this before will know that it will be anything but simple, but we are going to have fewer bandings. The aim to have the scrapping of these so-called nuisance tariffs, which effectively cost more in administration than they bring in revenue, and try and remove some of the more complicated rules. What the aim in all of this is to try and make this as administratively simple as possible, you know, bearing in mind it is a complex topic, and also try and enable us to negotiate preferential tariffs with certain countries around the world for certain types of goods. So there is a new website that's up and running where you can check tariffs which are going to apply to goods from the 1st of January based upon the deals we've negotiated so far. It will also show you what the existing tariff is under the EU common external tariff. So it should be quite easy for businesses to check what the difference is and how they're going to be impacted in terms of the import duties they're going to have bringing goods into the UK. I would also point out that this new tariff applies worldwide and it will change country by country, but it will impact businesses that are importing from outside the EU, not just those importing from the EU. So that's quite a helpful tool, and you can look up by commodity code or by some kind of description.
I presume that can be found by just typing in tariff checker, can it? Tariff checker UK into Google, you'll find it?
Absolutely. If you type in tariff checker gov, it will come up as your top Google result, and it's quite a friendly website for a gov website, I've got to say. And as I say, if you know commodity codes, that's really good because you can search by your exact product. If you don't, you can search by description. You can get a whole list and try and pick what's closest. The second major change is to do with postponed import VAT accounting. Now, anyone that currently imports goods from outside the EU will know you've got to pay import VAT on bringing those goods into the country. Now, come 1st of January, well, that's going to apply to goods coming from anywhere in the world, not just those coming from outside the EU. Now, in order to combat the cash flow implications of all of that, the government have introduced postponed import VAT accounting. And what that means is rather than pay import VAT at the border, instead a VAT registered business will be able to account for that import VAT on their VAT return in much the same way as reverse charges or acquisition accounting work now. So for businesses which are able to recover their VAT in full, it will be a simple in and out on the VAT return and no cash will actually need to be paid over to HMRC. So that's quite a positive change. So for businesses importing from the EU, you're not going to have any cash flow difference as far as that is concerned as you do now. And it's actually a benefit to traders that are importing from the rest of the world. So you're no longer going to have to fork out and pay over VAT to HMRC and then wait up to 3 or 4 months to reclaim that on your own VAT return. So that's certainly a positive change from all of this. Now, whilst you won't have to pay import VAT at the border anymore, you still have to pay duties. So this is customs and excise duties that may be due on bringing goods into the UK. Now, we've always had this option of applying for duty deferment accounts, which rather than having to pay duties as and when goods hit the port each time, you can instead consolidate it and make one monthly payment about a couple of weeks after the end of each month. Now, historically, those duty deferment accounts have required guarantees in order to protect HMRC against non-payment. HMRC have, however, just announced that there's going to be a simplified system. So obviously import VAT is no longer relevant, so we don't have to worry about guarantees for that anymore. It is just the duties that are going to become due. Now, where duties on average are less than £10,000 per month, and that's the amount of duties payable, not the value of the goods, and the business has a good compliance record, so that means generally filed tax returns and paid taxes on time, there will be no guarantee required. Business can apply for a duty deferment account and then just make one monthly payment for the duties of goods coming in. For companies over £10,000 of monthly duties, if they've got a good compliance record, they don't necessarily need a guarantee. They will just have a higher burden of proof to HMRC just to prove that they're a good, liquid, stable business, and that duty deferment account can still be provided without a guarantee. We can just move on to the next slide. There are going to be a whole load of changes as far as e-commerce is concerned, and what I mean by that is really goods and services which are sold online. Now, I'm going to come on to some of those in a bit more detail later, but I just wanted to point out that low value consignment relief is going. So for the UK, that will be abolished completely from the 1st of January. And that's what allows goods below a certain value, £12, to come into the UK without any VAT or duties at all. From the EU, that's going to be delayed until the 1st of July, but they are going to be implementing similar changes. And there's going to be some quite wide-ranging VAT implications to e-commerce, particularly where goods are sold through online platforms like Amazon, Etsy, not on the high street, places like that. But we'll come on to that in a bit more detail later. And then the final point I just wanted to mention on this is to do with Northern Ireland. Now, anyone that's been following the process fairly carefully will know that Northern Ireland has been a massive complication in all of the Brexit negotiations and continues to be so. Now, the plan is that Northern Ireland will continue to be part of the EU customs union, and that's really there to prevent a hard border coming back in between Ireland and Northern Ireland, and that's all part of the peace process. No one wants to return to the kind of the violence of the past decades, and that's being seen as a cornerstone of all of this and something which there is no room for negotiation on. So we've got this now quite complex Northern Ireland Protocol about how the trading relationship between Northern Ireland and Ireland, and indeed between the UK and Northern Ireland, or I should say the rest of the UK and Northern Ireland. That's very complicated. It is still being iterated at the moment. So if you do have any trade which passes through Northern Ireland, you may need to pay special attention to that. Okay, so that was a bit of an overview of import process, but before we talk in detail about the trading arrangements and VAT's implications of selling to and from the EU, I think it's really important we understand what Incoterms are. Now, John's going to talk a little bit more detail about Incoterms in a moment. I just wanted to say that from a VAT point of view, it's incredibly important to understand what your Incoterms are and what you've agreed, and this is whether you're selling goods or indeed you're buying goods, because this will determine whether you have any administrative or financial responsibility for import VAT and import duties. So, John, perhaps you can give us a bit of an overview of Incoterms and what they mean.
Thank you very much, Dan. If we have the next slide, please. So Incoterms, it's shorthand for the international commercial terms, and they've been around for donkey's years, since 1936, in fact. And they were pulled together by the International Chamber of Commerce, and the ICC, they update them every 10 years. So the current version are Incoterms 2020. That's not to say that you won't see contracts that refer to Incoterms 2010 or even earlier Incoterms 2000. It obviously depends when the contract was entered into. And as Dan said, that they're key because they determine which party bears all the costs, well, where the costs are allocated in the transport chain, should I say. So it could be that one party, that the seller is responsible for insurance and transport, and the importer is responsible for duties. There are 11 Incoterms, so they range from Ex Works, EXW, through to DDP, which is delivered duty paid. And the EXW one favours the supplier and DDP favours the buyer. And there are shades in between. And if we go to the next slide, I can demonstrate how they differ. So there's a few things to note. If you're going to use Incoterms, it's quite important, well, it is very important that you use them correctly. So it's the 3-letter code, EXW, then open brackets, then you insert the named place of delivery. So that would be at the supplier's, the seller's location, and then Incoterms, and then the version of Incoterms that you're using, which should be if you're new to putting a new contract in place, it should be Incoterms 2020. When using the Incoterms, you also need to check that they actually apply to the method of transport you're going to use. So in this slide, you can see for both for Ex Works and delivered duty paid, it can be used for all types of transports, whether it's rail, air, road, or shipping container. You need to make sure that you've got the right one in place. In terms of where responsibilities lie, if we look at Ex Works, on that side, the seller's sole responsibility is to make the goods available. Loading of the vehicle that's going to take the goods away falls to the buyer. The buyer's got to arrange the transportation. The buyer's got to clear the goods for export and import. And everything, once it leaves the factory gate, the supplier's fulfilled all it need do. If you compare that with delivered duty paid, it's the exact reverse. So what we've got, the seller is responsible for delivering the goods to the buyer. The only thing the buyer is responsible for is unloading the goods. The seller transports, the seller clears for export and import, and the seller pays the duties. As you appreciate, that's a big difference in position. Now, the word of warning, I've seen many contracts that have DDP within them for EU trade because no one really cared, because there was no duty payable at the time. As of the 1st of January, that will become a very big issue. And I'll hand back to Dan now.
Thanks, John. Yeah, as John said, I mean, I'm having the same experience when I'm looking at things with clients. Once upon a time, you know, we've had this long-term training arrangement with the EU where we don't have a border, we don't have import duties, so terms in the contract tend to be less important. You know, once everyone knows who's responsible for transporting the goods, whether something is delivered duty paid or not, was kind of a moot point. But where we do have these historic arrangements, perhaps they just need reviewing now to understand whose responsibilities in there. So before we actually talk about the kind of the VAT side of things, I just want to look at kind of 3 examples here of responsibilities for kind of export-import declarations using some of these examples. So John mentioned that Ex Works is one end of the scale, where really the buyer is responsible for everything, taking possession of the goods from the seller's premises. Now, in that scenario, you may think, well, that's nice and easy for the seller, particularly if we're a UK business, we don't have any responsibility there. Now, whilst that's true, we do need to think about some of the practicalities of it all. So if the buyer is going to be responsible for the export declaration from the UK, are we going to have the relevant records to support what we've done from a VAT point of view if HMRC come and do an inspection at a later date? So we've sold goods to a supplier in Europe, they've come and collected them from our premises, taken them out of the UK, they've dealt with all the declarations. Well, we probably are not going to have paid any VAT on that. We will have zero rated it. And HMRC, they're going to come along and say, great, do you have proof that those goods have been removed from the UK, such as an export declaration? Well, if the customer's dealt with all of that, have we got a process in place to make sure we obtain copies for our records to satisfy the UK tax authorities? What if we've got a kind of a sale DDP? So the other end of the scale, where we're responsible for getting it to the buyer's doorstep. Well, we're going to have to deal with the export declarations in the UK, but it means we're also going to be the importer of record in the EU. So we're going to need to deal with import declarations there. Do we know what we're doing? Have we got an agent appointed? We're going to have to deal with the VAT and duty issues there. Are we set up to be able to deal with that? And there's a variation which to all of this, DAP, which is essentially the same as DDP, except the buyer takes responsibility for import declarations and duties. So the seller is still responsible for getting the goods to the buyer's door, but it means the buyer is going to be dealing with the administration and the tax side of things. And that is probably a good halfway house for many UK companies that are going to be trading to the EU, but for reasons we're going to come on to in a bit more detail. So it doesn't necessarily need to upset your practical arrangements of who's going to arrange transportation and delivery, but it does mean that the VAT and duty side of things is greatly simplified, particularly if the business is already established in that country. So if we can move on to the next slide. So I'm first going to talk about a supply of B2B goods. So what I mean by that is a UK business that is selling goods to another business in the EU that's also VAT registered. So it's important to understand who's going to be the exporter and who's going to be the importer. And I think in many cases, we're going to want to try and arrange something with our buyers that we are dealing with the export, declarations and process from the UK, for practical reasons we spoke about earlier. But also from their point of view, do they really want to be involved in UK export declarations if they're based somewhere in the mainland Europe? But we probably want them to be dealing with the import side of things. Do we really want to have to deal with import VAT in, say, France, that we then got to get at the process to recover, when if they're already registered in France, they can deal with it through their existing registration? So where we stand at the moment, if I'm a UK business and I'm selling to another business customer, say in France, there is going to be import duty and import VAT due there, regardless of who's responsible for it. If I am the importer of record as a UK business, I'm going to have to file those import declarations. I'm going to have to pay over that VAT and duty. And I'm almost certainly going to have a VAT registration requirement in France to be able to recover that import VAT. I'm also likely going to have to charge my customer French VAT, which they're going to have to recover through their own VAT return. I may need a fiscal representative in that country. So a fiscal representative is a local organisation, often, which will represent a non-established business in the EU territory for VAT reasons. So the UK, no longer being part of the Union, is now a third country. If I have a VAT registration in France, because I'm not established there, the French rules require me to have a fiscal representative, which is just someone who's going to be jointly responsible for my VAT obligations. So there are plenty of third-party companies that will deal with that for you, but as you might imagine, there is a cost involved. Something I haven't touched upon yet is that we will almost certainly require EORI registrations in the EU come 1st of January. Now, most UK businesses will already have a UK EORI number. And I would say that as of today, the UK EORI number is an EU EORI number. But from the 1st of January, as you may expect, that's no longer the case. For anyone who is not aware of what an EORI number is or what it does, is that is the number that goes on import declarations and allows you to bring goods into a country. From the 1st of January, if I want to be the importer of record into an EU country, I need to have an EU EORI number. I can only have one EU EORI number. I don't need a different one for each country I'm going to import to. Just one number will do it. So if I'm regularly going to be an importer of record come 1st of January, I do need to think about getting an EU EORI number, so I'm not going to have my goods held up at the port. It's worth noting that there is no requirement for UK businesses to have any kind of EU subsidiary or legal entity come the 1st of January. I've seen a lot of stuff out there that says, well, if you want to be able to trade with the EU and you want to be able to deal with those responsibilities, you need to set up a subsidiary. That's not the case. Indeed, that is one option, but for many businesses, a branch may be more applicable. Depends on the country and the circumstances. Something else I imagine many businesses are going to want to consider as well is whether or not they want to move some stock to the EU. Because we're going to have a border and there's going to be customs processes, particularly for time-sensitive goods, it may be preferable to have some stock stored in the EU so they can be quickly dispatched to different locations rather than through the UK and potentially risk being stopped at the border, going through additional checks. And again, that's going to come with some VAT obligations. So then we've got the reverse of that. We're going to have businesses in the EU trading with the UK. And that could also include a foreign branch or subsidiary of UK businesses. I know certainly many of our clients have establishments based in the EU, perhaps manufacturing, that then may be transferring goods back to the UK at a later stage. We're still going to have to deal with everything I've just talked about in reverse. If we're buying goods from the EU, who's going to be the importer of record? We may have arrangements at the moment with our supplier where they bring everything to our doorstep, they're responsible for everything. Come the 1st of January, might it be more appropriate that we're the importer of record? As I said earlier, we would be accounting for import VAT on our VAT return, so no big drama as far as we're concerned. It may make administration easier for them. If they're going to be the importer of record, they're going to need to have a UK VAT registration. They're going to need to have a UK EORI number. They're going to have to deal with all this administration, paying import VAT, and then going through some process to reclaim it. Like the EU, we're not going to have any requirement for an EU business to form a local subsidiary. They may need to register a branch. It's also worth noting that we have no requirement for a fiscal representative in the UK, so that does make things a little bit simpler for them. But I think the key takeaway of all of this really is about who is going to be that importer of record, because if the importer of record is going to be the business that is not established in the country in which the goods are coming into, there are actions that need to be taken. So in a nutshell, registering for VAT in the country you're going to be importing to, and thinking about all that administration process and the duties. Now, the VAT, whilst there is administration involved, there shouldn't be any cost. It's probably just going to be a cash flow issue. There may be VAT payable that can then be reclaimed, but it is the duties which are going to be a cost for the parties involved. And it's going to be important to agree who is going to bear that cost. Particularly if you've got, say, high volume, low margin goods, and you've got a 10% duty rate, does that erode your gross profit margin? Is there enough in there now to make it worthwhile? Are you going to be incurring duties that you weren't planning and didn't have in your finances? So understanding what duties are going to be payable and who's bearing that cost is going to be quite key. So I now want to talk a little bit about a B2C sale of goods. So what I mean here is a business that's selling directly to consumers. Now, this is where it could get quite complicated indeed. Now, anyone that currently sells to consumers in the EU may be aware of the distance selling regime. So as things stand at the moment, if I'm a UK business selling to consumers in the EU, in the first instance, I account for UK VAT on that sale. However, each EU country has a distance selling threshold, which is normally €35,000. If I sell goods exceeding that value in a calendar year, I have to register locally in that country and charge local country VAT. Now, from the 1st of January, because the UK is not going to be part of the EU or part of the customs union, that is distance selling thresholds will no longer apply to us. If I sell a single £1 of goods to a consumer in the EU, there will be EU VAT that is due on that. So if I'm selling to a consumer in, say, Spain, a £20 t-shirt, then Spanish VAT will be due at the border when those goods enter Spain. Now, for businesses that want to rely on quite a seamless process for customers, at the moment, everyone's used to, you can go on a website, you can order your goods, you pay, and what you pay on the website, that's it. The goods will be delivered to your doorstep. You don't have to worry about it. So if I'm a consumer in Spain, I might go to a UK retailer and buy £100 worth of clothing. That will be delivered to my door. Nothing else to worry about. From the 1st of January, if no action is taken, what will happen is I will pay that UK business for the goods, but then I will get probably something through my mailbox, through the Spanish equivalent of Royal Mail, that says I've got to pay some import VAT and duties. So is there now an extra cost for the consumer that they weren't aware of? Is there extra administration and hassle that will make it less likely they want to buy from that business in future? So the key for UK businesses is going to make it clear whether or not there's going to be VAT or duties that are payable by the customer. Now, for some businesses, they may just accept that that's what you're going to have to do, pass that responsibility for the customer, because they don't want to have to deal with the VAT and administration of sending goods to lots of different EU countries. However, for businesses that perhaps have a higher volume of sales, what you may want to consider is having some kind of EU base which you import goods into first. So I could, for example, decide I'm going to route all of my EU supplies through the Netherlands, and I'm going to use the Netherlands as my import base. Now, in that scenario, I can import my goods into the Netherlands, deal with import VAT and duties there, and then use the Netherlands to dispatch my goods to the rest of Europe. In that scenario, the existing regime would effectively apply. In the first instance, I would apply Dutch VAT to all my sales to the EU, subject to the distance selling thresholds. And then if I go over them, I'd have to register for VAT in those countries, as I do now. But what that would mean for the customer is there's still a seamless process. I buy goods from a UK supplier. I don't have any VAT or duty obligations to have to worry about. So I think that's quite a crucial thing for businesses selling to EU consumers, because there's that right balance to try and find between being attractive for your customers for a place to buy, having good quality products and the right pricing and the ease of it all, and striking that balance with the business having to comply with lots of different tax obligations in the EU that may otherwise become onerous. There's not a whole lot of point in spending a lot of money and having some kind of EU base of operations dealing with all the extra administration if your volume of sales is quite low. But that's something each business is going to need to consider. We then have the reverse of that for the UK. So much in the same way, EU businesses selling into the UK will either need to tell their customers that UK VAT is going to be payable effectively at the border by them, or they're going to need to consider registering for VAT in the UK and dealing with the UK VAT obligations. Now, I would say here that we've got a few differences to the EU. Now, I mentioned earlier that low value consignment relief is disappearing in the UK from the 1st of January. Now, we're going to have some new e-commerce rules that apply. Now, there are two aspects to this. Number one, For businesses selling through online platforms such as Amazon and Etsy and eBay, all those, the obligation for accounting for UK VAT to UK consumers is going to pass to the platform for non-established businesses. And that won't just apply to EU businesses, that's worldwide. So come 1st of January, the likes of, say, eBay is going to have to account for the VAT on sales to UK customers. So that is a little bit of a simplification for EU businesses. But if you're selling direct to the consumers, not using one of the platforms, there's going to be some new rules that if the value of the supply is below £135, then that business is going to be responsible for registering for VAT in the UK and accounting for UK VAT, irrespective of whether or not the goods were in the UK or not at the point of sale. So I mentioned if we were selling to the EU, we've got the choice of just making the customer responsible for having to deal with the import VAT, or we could deal with it ourselves. The same is not necessarily going to be true in the UK. Any business selling in the UK, as I say, value of supplies of less than £135 will have to register for VAT in the UK. So that could be an extra compliance burden and indeed obligation that EU and indeed businesses elsewhere in the world may not be aware of. But the same is going to apply, making sure that website information is accurate and the customer is fully involved and knows what their obligations might be if it's not going to just be delivered to their door fully paid up. So it's worth briefly mentioning that there are a number of simplification rules associated with goods which are no longer going to apply to us. We've got the triangulation scheme that applies for goods that are moving directly between one EU location and another where there's a middleman. So very simplistic example, there might be a supplier in France, us, a middleman in the UK, and a customer in Germany. At the moment, those goods can move directly from France to Germany, and there being no VAT implications for any of the parties involved. From 1st of January, we won't be able to use those rules, and there may be VAT registrations required. There's some special rules for call-off stock, which allow businesses, UK businesses, to store certain stock in Europe without having to register. That will be gone. Certain simplification rules to do with installation of goods where the customer is VAT registered, where those goods are being installed, and then the distance selling rules, which I've already mentioned. Now, a big focus of what I've been talking about here has been goods, because that is what the bulk of the changes is going to apply to, but it is worth briefly talking about services as well. Now, I will just say for a B2B supply of services, there is not going to be any real changes from what we have today. So if you're a business that's just supplying services to other businesses, whether in Europe or otherwise, the same rules are going to apply. The changes are really going to affect a B2C supply of e-services. And e-services, that's really anything that you can sell electronically, kind of pre-packaged. So typically that's going to apply to things like games, music, films, and whether that's downloading, streaming, things like that. So think of it, anything that you can buy from Apple on the Apple Store. That's a good example. Now, we already have this scheme across Europe known as MOS, which allows for you to register for VAT under MOS in one country, and you account for VAT for each individual EU country in which your consumers are located at that local country rate, but you just declare it and pay it on one single VAT return. So that's a simplification measure to avoid businesses needing to register all over Europe and charge VAT all over Europe. We will no longer be able to use MOS in the UK from the 1st of January. So if you're a business that is supplying electronic services directly to consumers in Europe, you will need to register for the non-union MOS scheme. So as a non-established business, we will need to register for MOS in another EU country, and much the same process will apply. You will still have to account for VAT at each country's local rate. You will still submit it on one single return and pay it over that way, but it just won't be to the UK tax authorities. It will be to, say, the Irish tax authorities or the Dutch tax authorities, depending on where you may choose to register. And as you might expect, the same applies for businesses trading into the UK. So because we're no longer going to be part of the Union, for all intents and purposes, MOS will essentially cease to exist in the UK. Any business that is selling e-services to UK consumers will need to register for VAT here, submit VAT returns as per normal, and account for UK VAT on those supplies. So I don't think that's necessarily going to apply to many people listening today, because I imagine most of you are UK businesses, but certainly if you are selling to consumers in the EU, as I said, just electronic services, you do need to think about a non-union MOS VAT registration. So just kind of a final few thoughts from me on the VAT implications in case of a no-deal Brexit. And I do say in case of a no-deal Brexit, because these are some of the things where there may be some room for negotiation. As things stand at the moment, a UK business which is incurring VAT in another EU country has a process of reclaiming that. That's all done through HMRC, through an online portal. It's a relatively straightforward process. From the 1st of January, that option will no longer be available, albeit there is a slight transitional period. So for any VAT that's been incurred up to and including the 31st of December 2020, you've got up until the 31st of March to submit a claim for that VAT through the existing system. After that date, it's still probable that a UK business will be able to recover VAT incurred elsewhere in the EU. However, the application will have to be made on a country-by-country basis, direct to local tax authorities. So that means it'll have to be in local language, translated, different process, and they'll all be individually negotiated. So that's just something to bear in mind if you're incurring a lot of that elsewhere in the EU at the moment. That was a very quick overview of some of the changes. As you might imagine, we could talk for hours and hours on this subject. There is a lot to cover, but hopefully that kind of gives a bit of an overview on some of the main implications and the things that need consideration ahead of 1st of January, and some actions that may need to be taken. Now, on that front, I'm going to hand back over to John, who's going to talk about some of the contractual side of things.
Thank you, Dan. I'm going to talk about three things. It's not going to be in great detail. I'm going to talk you through some contractual issues that will become important as we move into the post-transition period. I'm going to talk about a little bit about product labeling, and then that old favourite, data protection, because if you thought you were done with GDPR, it may well be the case that you're not. If you could have the next slide, please. So contracts do matter. They underpin most trade, and of course they underpin cross-border trade. When I'm talking about contracts, I'm only going to talk about those contracts where English law applies, and it really doesn't make a difference. Contracts will usually have a clause at the end that says, typically at the end, that say this contract is to be understood in accordance with English law, or they may say another country's law. And I have seen it on more than one occasion where a client has said, can we not simply just change it to Swiss law because the Swiss customer would prefer it? Please don't do that. And anything I say about contracts is about English law contracts. The reason is there are fundamental differences as to the way that law has developed in England, well, in the UK, and the way it's developed in Europe. England's got a common law system and Europe has got a civil code generally. So what we're going to be talking about, well, I'm going to do some just headline issues. So delays around delivery, frustration, and I don't mean this talk is frustrating. I'm talking about legal frustration and does Brexit amount to a frustration event? And a bit about force majeure. And I've just got an eye on time, so I might scoot over variation and termination, but forgive me if I do. But let's see where we get to. If you have the next slide. I think everyone is aware that the biggest threat to UK business, whether importing or exporting, is going to be around delays at the ports. And typically, a contract might have a penalty provision within it relating to late delivery. Now, it's really important that people understand there are, in English law, there are two types of clauses. There are penalty clauses, which is where essentially what is being sought in damages, there's no relation to the harm caused. And then there are liquidated damages clauses, which are a genuine pre-estimate of the loss that you might suffer. So if I give you an example, if we have a contract, say for office furniture, and it has a clause that says for each week or whole week that you're late in delivering, you'll pay a 3% in liquidated damages, 3% of the contract value. And let's say the contract value is, say, £100,000. Say that office furniture is delayed in delivery by 2 weeks. We've got two lots of 3,000, making £6,000, and that would be an entirely enforceable provision. If the contract simply said, if you're late in paying, you will have to pay us £50,000, that is disproportionate, and that would be a penalty. Now, penalty clauses, there's a developing law around penalty clauses. Traditionally, they were seen as unenforceable. Parking management services, you'll be familiar with those. If you go to any shop, there'll be a little sign that says if you park here for more than 2 hours and you haven't got a receipt, we will charge you a fine of £150. People have argued that those are unenforceable penalties. The courts, however, are moving in the direction that they are enforceable. So just because something looks like a penalty clause, don't take it as read, it's unenforceable. The key thing is you understand what your risk may or may not be around delays, because it may well cost you money. The other thing to talk about is time is of the essence, and you will typically find time is of the essence mentioned around delivery and also around payment. So if you're the supplier, you will often look for payment to be time is of the essence. And what does time is of the essence mean? Well, in terms of delivery, the way that English law sees delivery, even if there are deadlines there for when goods must be delivered by, the general rule is that it's not a hard and fast provision. It's not an absolute condition. But by adding the words time is of the essence with regards to delivery, it does become a hard and fast delivery date. Now, the other way that delivery can become of the essence is not just by including those words. It could be implied by the nature of the goods. So if you've got perishable goods, it's likely that they've got to be delivered within a fixed time frame, and therefore time will be viewed as being of the essence. So if you fail to deliver on time, and time is of the essence, what does it mean? Typically, it will mean that you're in material breach of the contract, and the contract will have a clause that says if you're in material breach, the other party can terminate. Even if the contract doesn't say that, English common law has got the concept of repudiatory breach, and it will be viewed that that clause was so fundamental to the contract that the other party can terminate. If we can move on, please. Frustration and force majeure. These have been the topics of 2020. COVID-19 has introduced a whole body of work for us around frustration and force majeure. Clients have asked, what can I do? I can't perform my contract anymore. I'm slowed down and prevented from doing my performing my contract because of COVID-19. It's important to understand what frustration is. So frustration is an exceptional remedy in English law, and it only applies in limited circumstances. It applies when the contract essentially becomes impossible to perform. So in order to get to that point, the event that frustrates the contract, it's got to happen after the contract came into force. So it can't be a pre-existing condition. It's got to be something that happened. The courts quite rightly see it that if the condition existed, the event or condition existed beforehand, you can deal with it. And it's got to be the type of event that neither party is at fault. So a government order is not in the control of a party. So it's got to be without fault. And it's either got to render the contract impossible to perform, or it's got to make the contract so substantially different that either party would have contracted on that basis. And if there is a genuine frustrating event, the parties are relieved from performance of the contract. And the contract is essentially declared void. It's not terminated, it's declared void. And there is a difference between the contract being void and one being terminated. Just in terms of what happens if there's been prepayments, there is a statute that sets out where the losses will fall. It's Law Reform Frustrated Contracts Act, 1940 something or other, 47 I think from memory, but I don't deal with that element. If anyone does think they've got a contract that's frustrated, it would be one of my dispute resolution colleagues that would get involved. So is Brexit a frustrating event? Yes, in one sense. Is it legally frustrating? The answer is no. It has been said to be no in one case. So this is the sorry tale of the European Medicines Agency and the battle that they had with their landlord, Canary Wharf BP4 T1 Limited. The European Medicines Agency have been headquartered at Canary Wharf. They've got £500 million lease. And following the referendum, in 2016, they said to their landlord, really sorry, but because of Brexit looming, we're not going to be able to stay in the UK, and we see the contract has been frustrated. The courts, however, looked at it and said, actually, no, European Medicines Agency. Yes, you may want to move to Europe, but the fact is, you could still be based in Europe, in the UK, you could still be based in the UK and perform exactly the role that you need to do within the EU by being based in London. And their claim the frustration, it was found that there was no frustration and the contract stood. So very likely that no one, it will be exceptional for someone to argue that Brexit is a frustrating event. That is very different from COVID-19 because there were circumstances where we could argue that a contract was impossible to perform, particularly where there was a government order saying you can't do this, full stop. The contract could be frustrated. Next slide, please. So force majeure is the types of clauses that are within an agreement that are there to help deal with the situations where a party is either prevented, hindered, or delayed in performing their contractual obligations when a certain event occurs. So, act of God, pandemic. So that, as I said before, COVID was very much relevant to that. The events have got to be beyond a party's control, and they've got to be the sole reason for the failure to perform. Now, questions around force majeure and Brexit, it is possible that Brexit may amount to a force majeure event. And it's going to depend on a number of factors. In particular, what does the contract say in relation to the force majeure event? Does it simply say if a party is delayed by a force majeure event, or does it say if a party is prevented, hindered, or delayed? So that's a wider scope. And then we need to think what the force majeure event is. It could be as simple as something as beyond the party's reasonable control. Now, one might think that Brexit might sneak in that way. Well, it may do, but it does depend when the contract was entered into. So if the contract was entered into in post-2016, it'd be difficult to argue that Brexit was beyond a party's reasonable control, because we all knew Brexit was coming. So the real answer is you will need to look at your force majeure provisions before you rely on it. And that is going to be the key. So they may be relevant, they may not, but it will depend on the particular drafting of the clause. Next slide, please. So, variation. This could be a way forwards. I'm going to keep this quite short, because typically to get variation, you need agreement. And although it can be varied by a contract can be varied by a course of conduct, typically you need agreement. And if your contract isn't working for you, it doesn't necessarily follow that your counterparty is going to be saying, yeah, not a problem, I'll agree a variation. So if you are looking to vary, you're going to have to think about what kind of incentives you can offer to the other side in terms of getting a variation. And typical things that you might think about looking for variations around might be around how you deal with delays, or around currency fluctuation, or around tariffs. And it is quite possible to include Brexit or material adverse changes clauses within a contract. And indeed, some people might have already got those clauses in their contracts, but you might look to vary the contract. On exchange rates, you could always, you can de-risk the currency fluctuations by hedging. So if you are going to vary, you've got to look at reallocating the risk generally. And I've given a short example there. I won't go into that, just conscious of time. Go to the next slide. Termination, the I'm a celebrity option. Get me the hell out of here. There are three ways to get out of a contract. Common law, which is where we're talking about repudiation. Contractual provisions, which typically might be around material breach, persistent minor breaches, or by agreement. The key thing, if you are going to terminate, or if the other side is looking to terminate a contract, in fact, it was the very first call I had this morning, was a business saying, oh, the other side have just terminated a contract, but they were supposed to give us 6 months notice. The key thing is to check what the contract provides, because if the contract did provide for 6 months notice, the other side have got that wrong, and it entitles the non-terminating party to sue for damages. It's really important to take advice about termination and exercising termination provisions. And even if you're agreeing termination, you should take legal advice, because you might want to think about what is actually released when you what obligations are released when you end the contract. So there may be certain obligations which you want to preserve. So for example, typically there may be confidentiality. You may want to hang on to, you may be due monies under the old contract. You certainly won't want to release that obligation. So the key words there are look to take legal advice, whether on the receiving end or terminating a contract. Next slide, please. So moving away from contracts, I thought I'd just talk shortly about a new mark for England, Scotland and Wales, the UKCA mark, which is UK Conformity Assessed. And that is to replace that CE mark, which many of us will have seen on domestic products and never really thought what it is. As a consumer, if you're in the business of producing goods, of course you will have known what a CE mark is. So the CE mark is the EEA mark to show that a product is safe for sale in the EEA. Because we will no longer be part of the EEA, we can't use the CE mark. We have to have our own mark, the UKCA mark. And to complicate things a bit further, for Northern Ireland, there is another mark, the UKNI mark for goods sold in Northern Ireland. I appreciate the 1st of January is not far off, and many of us will be sitting on products which have got CE marks and thinking, what the hell do we do? Well, the good news is, if you've got a product which is CE marked, generally, caveat it, generally, you'll be able to continue using that CE marked product until the 1st of January 22. After that point, when you put goods on sale in the UK, it will have to have a UKCA mark. Now, one thing that I should mention is it's possible to dual mark products. So, or even tri-mark products with a UKCA mark, a CE mark, and a UKNI mark. As long as you comply with the regulations for each, they can be there. If you're selling goods into the EU, you must ensure that they have a CE mark. The UKCA mark will not be recognised in Europe. Could I have the next slide, please? And finally, we get to data protection. And this, I know that lots of businesses had a headache with GDPR in 2018. I'm afraid for some, not for all, there may be further headaches around GDPR or the UK version of GDPR and the EU version of GDPR, which we'll be faced with come the 1st of January. To keep things simple, I've just broken it down into 3 bits. So if you're a UK business with no EEA contacts and no EEA customers, there's no change. You're simply going to have to comply with, you'll have to comply with the current law. Now, in terms of GDPR and the Data Protection Act 2018, the EU GDPR is going to become part of the UK's data protection regime, fully part of it. And it will be incorporated into the Data Protection Act 2018. So all you need to do is make sure that you comply with the requirements of the DPA 2018 and UK GDPR. There is the possibility for UK GDPR to diverge from EU GDPR. Let's hope that's not going to happen for some time. Then we turn to a business that might send or receive personal data from the EEA. Again, there is some good news. If you're transferring data from the UK to the EEA, there's going to be no change in the rules. You can do that. However, if you're receiving personal data from the EEA, you will need to put in place a transfer mechanism. And typically, that will be by using the standard contractual clauses. And they are standard form documents. So there are two types, one for controllers to controller transfers and another for controller to processor transfers. You'll also need to review your privacy notices and other documents to identify any minor changes. So typically a privacy notice will include information about international transfers, and you will just need to make sure that your privacy notice reflects what is required post the 1st of January 2021. For those businesses that have got an office or a branch in the EEA, or if you have customers in the EEA, so it could apply to an e-commerce business, B2C business. The bad news is you're going to have to comply with both the UK GDPR, data protection regulations, and the EU data protection regulations. So you're going to have to comply with both. And unless your processing is anything other than occasional, you may need to designate a representative in the EEA. Rather unhelpfully, there is no guidance as what is meant by not occasional. I'd say if you're transacting with European customers, you undoubtedly will need to appoint an EEA representative. And it's not dissimilar to the fiscal representative that Dan mentioned earlier. I appreciate that's a kind of whistle-stop view of everything, but I'm keen that we had a bit of time left over at the end. So I'm going to end here. Oh, there are some resources, and yes, these slides will be available afterwards. I know there's a lot of stuff there, but the slides will be available after we've finished. As to resources, the .gov.uk website is very good, and you can there's a Q&A, so you can go through about your business, how you're interacting with Europe, and it will deliver a tailored response as to what you may need to do. Of course, the EU have got their own documents. I've provided a link to a checklist there. And then in terms of data protection, we've got the ICO's website, and that's got dedicated pages around transitional arrangements. And that's me done. Thank you.
Thank you, John. We've had plenty of questions coming in, and of course we had plenty submitted in advance when you registered. So I'm going to launch into them, and because of time, I'm going to ask the two panelists to answer them as quickly and succinctly as they possibly can. So the first one is probably for Dan. Are there any issues with the accounting software currently being ready for the start of the year?
Yeah, I think for most businesses, their accounting software will be set up for the current regime. Certainly, if we're talking VAT returns, things like that, there will be a few changes going forward. No EC sales lists, the way you account for things on your VAT returns are going to change. In most cases, it's just going to be a case of reviewing your software and maybe updating VAT rates and making a few changes behind the scenes to make sure everything's going to be entered correctly. Okay.
And you mentioned EU EORI numbers. How do you apply for one of those?
It depends which country you're applying for it in. Each country's got their own system, but for most of them there is an online process. Some of them are very quick and simple, like the Netherlands. Others are take a lot longer and a bit more drawn out, say Germany, for example. So it depends which country you're applying for, but I would say you should seek to get an EORI number in the country in which you are mainly going to be importing into. But as I said earlier, you can use any EU EORI number to import to the EU.
Another question, given the complexity of what you've spoken about, Dan, there's going to be a lot of mistakes made. And how tolerant are HMRC going to be?
Well, yeah, it's a good question. HMRC have said they're going to take a light touch approach for the first 6 months. Now, in practice, they tend to extend a little bit longer than that. Generally speaking, where a business clearly is trying to be compliant, they're not going to go heavy-handed and you're not likely to get any penalties. If you're just saying, oh, it's too much of a big deal, I can't be bothered to deal with it, and you're just not even making an attempt, they won't hesitate to kind of slap penalties on for errors and things.
Could I just add there, Dan, that what you describe is not dissimilar to the kind of process that the ICO took around GDPR. So when GDPR came in May 2018, there was it was very much a light touch approach, and they were more keen to see businesses were making attempts to comply than doing nothing at all. And that was just an observation.
Dan, you mentioned about, you already covered the consequences of selling consultancy service, recruitment type services, and some digital services. Does that extend to software and subscriptions?
Yeah, it does. So software would fall within e-services. So where it's B2B, there's no change. So a B2B supply of kind of software and related services is still not going to be subject to UK VAT. But if you're supplying software to consumers, and that's not necessarily that download, it can be software that you're using online, can be, things that are up in the cloud, that will all fall within these services and will need to be dealt with under a non-union MOS scheme. Okay,
and we've had a few of the attendees mention there's a government grant available for software updates required by Brexit, and I think that you can find details of that. And I think through MHA we provide some training for that particular grant.
Yeah, it's probably worth mentioning that there are a few different government grants available for Brexit. So there's 3 specific ones. One is to do with training on customs processes. There's another one for software, and there's another one for hiring. So if you've got any of 3 of those categories, so if you've got staff that you need to train on the customs process, or you're looking to hire people to do it, or indeed if you need to buy new software, update software for all these changes, there are grants available. You can apply. There is a limited fund, so the sooner you apply, the better. And then if you get that grant, it's available to spend to help defray some of these costs.
Okay.
Perhaps we could provide a link for that with our slides for the website. You can go to apply for that grant.
Good idea. John, quick one for you. If I'm buying materials from the EU or further afield and my costs have gone up significantly, is there anything I can do to change my pricing to my end customer where I've got a fixed price?
We're back to the world of variation. Unless you've got a price review clause in there. So sometimes there will be a clause that says we can increase the price if our costs increase by X%. And we can pass the price on to you. Otherwise, so there's if you've got that clause, great. If not, you are back to variation, and you've got to find a way of getting the other party to agree to that change. It's got to be you've got to make something, make it worthwhile to them, and that's going to be the kind of key to unlock these things. You will not be able to unilaterally impose a price increase.
Okay. Dan, do we know if postponed VAT accounting is available to other EU countries to make it easier to trade with the UK following Brexit?
It It is for some, but not many, and often they will require you to have an EU establishment in order to use it. So the safest thing is to assume not, albeit, like I say, there are some countries which do have that available.
Another one, how do you know which countries require a fiscal rep? Is it all of them in the EU?
It's not all of them, but it is most of them.
Right.
And again, you have to look on a case-by-case basis. But there are some resources on the Europa website which will list individual countries' requirements.
Okay. Someone has asked me to apply for a TSP code. Do we need one of these?
Depends. We would need to know the full circumstances.
Okay, that was quite a niche one then. If I ship EXW all the time, I don't need a URI number. Is that correct?
Yeah, that would be right. So if you're supplying goods ex works, it's your customer's responsibility to bring them into the EU. Therefore, you're never going to need an EU VAT registration or EURI number.
But you did caveat that on the saying about what documentation you might want to keep.
Yeah. Indeed. Yeah. Certainly for the import side of things, they're not going to need to deal with that.
Okay, we are running out of time, so I'll try and skip through, come up with some of these last questions. So regardless of whether a deal is done, we will need to use VAT Z rate for our sales to EU. Is that right?
So if regardless of whether or not a deal was done, so the VAT will not change from what we've discussed today. A deal is going to focus on procedures, administration, and indeed duty rates. But as far as VAT is concerned, all sales to the EU will not be subject to UK VAT, but the goods coming into the EU will be subject to EU VAT in one form or another.
So what should companies be telling their customers and suppliers in the EU right now, and where do they get that information from?
It really comes down to whether or not you're doing B2B or B2C. I think B2C should be an easier conversation because, you know, if my customer is VAT registered in the EU, the country it's going to, they should be well aware of what the local country requirements are far better than I am as a UK business. It's probably easy enough to arrange that. And it's just really about understanding whose responsibility the duty falls, who's paying that, whose bottom line is that hitting. And I think that's what all businesses need to be doing, just having those conversations and understanding whose responsibility is whose, and where are the costs going to lie. And that may form part of any kind of renegotiation.
Okay, conscious of the time, and also that John has got a deal that he needs to go on to in a moment. So I'm going to ask one final question to you both. If I've been watching this webinar and I've not done anything at all to prepare for Brexit, what are the top 3 things I need to do this week?
Do you want to go first, Dan?
Sure, why not? I think for me, one of the important things is making sure you've got your EURI numbers. So whether that's UK or EU, if you need one, get the application process in now. It doesn't cost anything unless you're engaging someone to do it. It should be relatively quick to do, but that's going to be crucial to kind of get your goods over the border if you're an importer of record. As I just mentioned a minute ago, it's really understanding your customer and supplier relationships. That maybe review contracts and arrangements just to understand whose responsibility lies where. And then the other thing is probably to make sure that you are updating your software or have got a process in place to make sure you update it ready for 1 January. So you're not going to get spurious entries on your VAT returns and potentially end up paying VAT you shouldn't do.
Thanks. From my perspective, I think the big risk for business is on the contractual side is going to be around delays. So I would certainly dust down my key contracts at the weekend, and I'd have a look at those and see what might happen if there are delays. And it will be not just, you need to think about delays for goods coming into the UK, delays for goods going outside the UK, and you'll also need to think about your onward supply chain. So if you're importing goods from the EU into the UK, which you're then selling on to other customers, and you're pig in the middle, so to speak, and you've got a delay from the EU end, what does the contract downstream say about delays? Because that is going to be the first thing that's going to come and bite you on the bum. The other things I would say, the other two things are around data protection. One, work out where you fall out of the three sort of streams that I identified. And if you do need an EU representative, I'd look for one now. There are lots of organisations out there offering it. In terms of what you need to do for an EU representative, what I suggested to a client the other day is they look at where, because you only need to appoint one EU representative. It's not like a fiscal representative where you might need a number in different countries. You just need one to cover the EEA. And what you might do is look where your largest customer base is. So if you're a B2C business and most of your sales are into Ireland, or the majority are into Ireland, it would make sense to appoint an EU representative into Ireland. Likewise, if the majority in Germany, look for a German entity to act as your EU representative. There's only a limited time to find that EU representative. Google may be your best friend at this stage.
Okay, Dan, I've got one last one for you. It's one that's come up a couple of times. What if we import from the EU to the UK and then back to the EU?
Okay, something that perhaps I should have mentioned earlier is to do with customs warehousing. So anyone who currently imports from outside the EU may already be aware of it. There are a couple of things businesses may want to consider about using a customs warehouse. And in short, a customs warehouse is essentially treated as if it's outside the UK for kind of import VAT and duty purposes. So goods coming into a customs warehouse are not subject to import VAT or duties until they leave. And that can be quite useful if goods are only temporarily imported to the UK for some reason. So a good example might be you're importing goods from, say, China that are destined for consumers in Germany. By using a customs warehouse, you can avoid having to pay import duties in the UK and then paying them again in the EU. But kind of attached to all this, there are a number of customs reliefs that are available that can be applied depending on the circumstances. Anything from temporary importation relief to goods coming in for kind of work to be done on them. There's a whole host of them. So if businesses are bringing goods into the country for a short-term or particular purpose, there may be some reliefs available to them.
Okay. Well, thank you. Thank you both to Dan and John for their terrific insight, and to the backroom teams for making sure the tech worked for us all. Hopefully that went hitch-free at everyone's end. I think it's worth saying there's an awful lot of information that's out there, and also an awful lot of changes that are coming our way. We haven't managed to cover everyone's questions, and I apologise if your questions weren't addressed. Some of them were covered by what Dan and John were able to say. I thank you all for watching, and so keep safe out there, and fingers crossed we get a good deal eventually. Thank you very much.
Thank you.
Thanks.